Namhla, are you on the platform?
Morning, Chair. Yes, I'm in the platform. There are 6 members who are in the platform as we speak.
Okay, it's myself. I see Honorable Peters. I see Honorable Ngaleka. Who else?
It's Honorable Tseke, Honorable Lotrit, Honorable Maluleke, Honorable Stock, and yourself.
Okay. All right. I think we're fine. We can proceed with the meeting.
And Honorable Suela, Chair.
Okay. All right. Thank you very much, honorable members. Welcome to this meeting of the Powers and Privileges Committee. We are convened today to finalize the sanction. The last time we met, we deliberated on on the closing arguments, and we came to a conclusion that all the members who were charged are found guilty. So we returned the guilty verdict. Subsequent to that, we communicated with the charged members the decision of this committee. We invited them to make representations on the sanction that this committee, after returning a guilty verdict, has to impose. We haven't received any representations, at least as far as I'm aware. All what we received in the past was a letter from their attorneys who were requesting that we must postpone imposing the sanction until the review application has been finalized. We took a view that we have to proceed with this because there is nothing legally stopping the committee from proceeding. So that's how far we are, honorable members. Advocate Mayosi, who has been appointed as an initiator, has finalized her submissions, and that's written submissions were sent to members. I hope members were able to go through the written submissions because in terms of the procedures, we will invite Advocate Mayosi to take us through her submission on before we deliberate on what should be the appropriate sanction. Do you have apologies, Namhla?
No, Chair, I didn't receive any apology, Chair.
Okay. All right. Is Advocate Mayosi on the platform?
Chairperson. Chair.
Honorable Tseke.
Oh, thanks very much and good morning, members. There's an apology of, sorry Namhla for not sending it through, of Honorable Tlagude Doris. She's attending another portfolio committee meeting. Yeah.
Oh, okay. Sorry, I forgot. Thank you very much, Honorable Tseke. I forgot about that. She did speak to me that she's attending, I think it's a joint committee on intelligence. They are meeting physically in Parliament in Cape Town. So she will be attending that meeting. Okay, Advocate Mayosi, are you there? Okay, I can see you.
I am here, Chair.
Okay, I'm now going to take this opportunity and hand over to yourself so that you can address this committee on your written submission on the sanction. Over to you.
Thank you, Chair. Thank you, Chair, and good morning to you and to the honorable members of the committee. Thank you for those introductory remarks. They covered in substantial part the introduction that I myself set out in the written submissions, so I will not repeat those introductory remarks as to what occurred between the date of the 4th of March, when the committee found the members guilty, and to date. And I can confirm to the chair and to the committee that to date, no representations of any kind have been received from the affected members. So the terrain where the committee is now is the stage which is set out in section 12.5 of the Act, which says that when a House finds a member guilty of contempt, the House may impose, in addition to any other penalty that the member may be liable to under the Act or under any other law, any one of the 7 penalties that are set out in section 12.5A to section G, 12.5G of the Act. That is the stage where the committee is now. And in terms of the Act, one or more of those penalties set out in section 12.5A to G may be imposed by this committee and also by the House on a member who's found guilty of contempt of court, such as any one of the 16 members that we're talking about here today. So I just want to take members to page 7 of my written submissions, which are the relevant considerations that this committee should be alive to and consider in its determination of what constitutes an appropriate penalty or penalties on the members who have been found guilty. The main considerations are 4 considerations, and I'll deal with them in turn, applying those considerations to the facts of this case. That is the seriousness of the charges which the members have been found guilty of, as well as the nature and the severity of their conduct, 1. Secondly, it's any acknowledgement of wrongdoing and remorse on their part, as well as their cooperation with the work of the committee. Thirdly, any previous incidents involving the named honorable members. And lastly, how the findings of guilt impact on the interests of Parliament as a whole. Looking at the first fact, which is the seriousness of the charges of contempt that the members have been found guilty of. In my submission, and I say this consistently throughout my written submissions, the charges of contempt that members have been found guilty of are of a serious nature. If I may summarize them, Honorable Members Matiase, Hlonyana, and Komane were each found guilty of 7 charges of contempt of Parliament. 2 of the 7 charges that they were found guilty of related to their persistence in raising points of order, and I say that advisedly in inverted commas, because the chair presiding over that session had ruled that the matters that they were raising were not points of order. That notwithstanding, they persisted with raising those points of order in a manner that was contrary to the rules, and also in a manner that was deliberately designed to, and I submit did in fact, at a level of fact, disrupt the proceedings of the day. As a result of their conduct, these 3 members, Matiase, Hlonyana, and Komane, were each found guilty of conduct constituting contempt in terms of section 13C of the Act, in that they improperly interfered with the ability of the House to exercise its authority and functions, and their conduct also improperly interfered with the performance by the Minister of Public Enterprises of his functions as a Member of Parliament. What they were doing, these 3 members, Honourable Members Matiase, Hlonyana, and Komane, was to persistently ignore the rulings of House Chairperson Mburoto, who presided over those proceedings regarding these so-called points of order that they had raised and which they were persistently continuing to raise. According to House Chairperson Mburoto, when Honourable Member Hlonyana said pointedly at some point, "This man is not going to speak here today," to her, that was a threat to the minister and that was a threat to the House. These 3 members acted deliberately when they refused to heed the presiding officer's rulings, which were final and binding according to the rules. Their conduct did in fact succeed in improperly interfering with and impeding the performance by the House of its authority and functions. It clearly succeeded in disrupting the minister's attempts to perform his functions and to fulfill his obligations to Parliament. This type of contempt cannot be anything but very serious. The remaining charges of contempt of parliament, of which honorable members Matias, Hlonyane, and Komane were found guilty, were related to their conduct in crossing the floor of the House in contravention of the rules, effectively charging towards the Minister of Public Enterprises as he was delivering his budget vote. And by doing so, they then, of course, again, improperly interfered with the ability of the House to perform its functions, the ability of the minister to perform his own obligations, and they created and took part in a disturbance within the parliamentary precinct whilst the House was meeting in contravention of Section 7E of the Act. So in addition to these 3 honorable members who were found guilty of these 7 charges, which individually are serious on their own, the remaining 13 members were also found guilty of all the 5 charges that each one of them faced. Again, each one of those 5 charges was serious. Those charges arose in large part from their own behavior or conduct in crossing the floor, charging towards the minister, and bringing the proceedings of the day to a halt. They engaged in conduct that required the presiding officer to invoke first Rule 70. Members will recall that Rule 70 is the rule that enables the presiding officer to order the named members to leave the House. Members will recall that House Chairperson Buroto first began to do so when Honorable Member Matias was on his feet, and she told him repeatedly, if you persist, you must either leave or take your seat. He at some point then took his seat. She then started to do that again with Honorable Member Komane when she rose and raised the same points of order that had been ruled to not be points of order. And she told Honorable Komane pointedly that I'm going to ask you to leave the House. At which point Honorable Matias then told House Chairperson Buroto, what we are doing is not lawful. You have to call us by name individually. Members will also recall that in her evidence, Honorable House Chairperson Buroto did in fact say that Honorable Matias had a point there, and what the rules require her to do is to call each member by name and ask them to leave the House. She then told Honorable Matias, Honorable Matias, you are giving me a task. I'm going to start with you. Honorable Matias, leave the House, at which point that exercise could not be completed because then the crossing of the floor en masse by the remaining affected members began. So after the invocation of Rule 70, or attempts to begin to invoke Rule 70 in relation to all the members, the presiding officer then had to invoke, as a matter of necessity, Rule 73, being the instruction to the Sergeant at Arms, and very quickly thereafter, Parliamentary Protection Services to remove the affected members from the House immediately. They engaged in conduct that was grossly disorderly in disregarding the presiding officer, and which properly, in those circumstances, then necessitated the invocation of Rules 70 and 73. These members acted deliberately. They engaged in conduct that created serious disorder and disruption in the House. They undermined the authority of the presiding officer by refusing to obey her rulings and repeatedly interrupting her as she was addressing the House. Their conduct was so serious that it was appropriate and reasonable for her to instruct the Sergeant at Arms and thereafter Parliamentary Protection Services to immediately remove them from the chamber for the remainder of the day's sitting. And during their removal, whilst their removal was underway by Parliamentary Protection Services, the affected members were physically intervening, obstructing and hindering their own removal in circumstances where the presiding officer had ordered that removal. Moving on to the second factor, which is relevant to this exercise, and that is whether or not there's been any acknowledgement of wrongdoing and remorse on the part of the named members, and whether or not they've cooperated with the work of the committee. As members will recall, because the members were not there throughout the proceedings, the chairperson entered a not guilty plea on behalf of each of the named members in respect of each charge of contempt of parliament that had been preferred against them. To date, the named members have not acknowledged any wrongdoing whatsoever. They haven't shown any remorse for their conduct. I won't repeat what members already know, which is what happened when the proceedings began on the 24th of November, which is that the members did not turn up. The legal representatives, in fact, did on their behalf and advised the committee that they were withdrawing their participation in the proceedings and they intended to instead bring legal proceedings in the Western Cape High Court, which they have subsequently done. Papers were delivered on the 11th of December 2020, where they seek various forms of relief, none of which include interdicting and preventing the continuation of this process. So whilst the affected honourable members could not be compelled, of course, to remain and participate in the work of the committee, one of the consequences of their election to withdraw is that they have not presented any mitigating factors and circumstances. What I submit remains before the committee at this stage are only aggravating factors in relation to the charges of which they have been found guilty. This lack of acknowledgement of wrongdoing and the lack of remorse should appropriately inform the penalties that this committee is to impose. Moving on to the third factor, which is whether or not there were any previous incidents involving the named honourable members. There are two members in relation to whom previous findings of guilt for contempt of parliament have been made, and in relation to whom penalties were imposed in that process. Those members are Honourable Member Matiase and Honourable Member Sonti in relation to their conduct in an incident that happened on 21 August 2014, which involved 20 members of the National Assembly during question time to the President. At the conclusion of the hearing that followed from that incident, Honourable Matiase was found guilty of 2 charges, namely 1, contravening Section 13A, read with Section 7E of the Act by creating and taking part in a disturbance within the precinct of Parliament whilst the House was meeting. And his conduct was basically shouting, banging on tables, refusing to obey the Speaker's instructions, and behaving in a grossly disorderly manner. It was found that Honourable Member Matiase's conduct interfered with and disrupted the proceedings of the House, forcing the Speaker to suspend proceedings temporarily and ultimately adjourn the sitting. The second charge of which Honourable Matiase was found guilty as a result of the 2014 process was contravening Section 13A, read with Section 7A of the Act, in that he interfered with or impeded the performance by the House of its authority and functions by remaining and refusing to leave the House after the sitting had been suspended, specifically so that he could leave and be removed from the chamber so that the House could continue with the business of the day. The consequences of his removal, it was found, was that the House was adjourned before completing its business for that day. The penalty that was imposed on Honourable Matiase was a suspension of 14 days without remuneration in terms of Section 12G of the Act. So where we are now as a result of the conduct that occurred in 2019 and the 2020 process is that Honourable Matiase has previously been found guilty and had a penalty imposed on him of contempt of Parliament under Section 13A for conduct contravening Section 7A and E of the Act. In the current process, he has been found guilty of contempt for similar conduct. For her part, Honourable Member Sonti was found guilty of contravening Section 13A, read with Section 7A of the Act, in that she too interfered with or impeded the performance by the House of its functions and authority by remaining in the House and refusing to leave after the sitting had been suspended, specifically so that she and the others could leave so that the House could continue with its business. The consequence of her removal, it was found, was that the House was adjourned before completing its business that day. The penalty that was then imposed on her was an order to apologize as prescribed by the House and a fine equivalent to 14 days' salary and allowances payable to her. Honorable Sonti has once again in these proceedings, as a result of her conduct on the 11th of July 2019, been found guilty of contempt of Parliament for contravening, as was the case in 2014, Section 7A, amongst others. She's once again engaged in conduct that improperly interfered with and impeded the exercise of performance by the House of its authority or functions. I'm advised by Parliamentary Legal Services that none of these penalties were in fact implemented by Parliament, but that is a matter for the committee to consider if relevant and if it deems fit during the course of its deliberations. Whilst it is the case that the remaining affected members, the remaining 14 members, had not, before the 11th of July 2019, conducted themselves in a similar fashion, it's respectfully submitted that this is outweighed by the serious nature and the severity of their conduct. Their conduct was intentional and it was deliberate. It's further submitted that notwithstanding the repeated cautions during the proceedings on the 11th of July 2019, and having had time during the course of those proceedings to reconsider their conduct, the affected members persisted and with conduct that was grossly disorderly and contemptuous. In addition to that, and in further aggravation, the members charged towards the Minister of Public Enterprises whilst he was in the process of delivering his speech, conduct which was itself unprecedented in Parliament. In relation to the fourth factor, which is the interests of Parliament, the interests of Parliament are of course advanced by orderly and robust debate and engagement. The conduct of the members on the 11th of July was destructive of orderly and robust engagement and debate. And I submit that their conduct had about it the hallmarks of a designed, concerted, and carefully coordinated effort to disrupt the proceedings of the day. And it did, in fact, succeed in doing so. Further considerations. Honorable Hlonyana stated, as is evident from the Hansard transcript and in the evidence of House Chairperson Buroto, when she got up to raise her so-called point of order, upon which, in relation to which the House Chairperson had already ruled, she said pointedly, this man is not going to speak today, it's not going to happen, it's not going to happen, we're not going to leave the House. Leaving the House, and he is not going to speak today, he's not going to speak. This was an indication of the attitude and state of mind of the named honorable members, which state of mind was amply demonstrated by their conduct when they crossed the floor, charged towards the minister as he attempted to proceed with the business of the day. House Chairperson Buroto, Mr. Colin Mahlangu, and the Sergeant at Arms, Mr. Malema, all testified that although they had witnessed disruptions of parliamentary proceedings previously, a disruption of this type, that is, one that involved members of Parliament crossing the floor of the House, charging towards another member as he attempted to discharge his functions, and the uncertainty that that situation, which was evolving fairly quickly, the uncertainty that that entailed, all of this was unprecedented, and it induced a sense of shock in them. In my view, these are additional aggravating factors in the consideration of the appropriate penalty in this matter. So where we are now is that the committee is required to consider what penalty or penalties are appropriate, if any, and these are the penalties, if any, that the committee will recommend should be imposed by the House on each one of the members. Section 12.5, as I alluded to previously, sets out a whole range of penalties in this regard. Section 12.5 must, of course, be read together with the provisions of Section 12.9 of the Act, which says that a member may not be suspended under Section 12.5G unless the House has found that the member is guilty of serious or repeated contempt, and none of the other penalties set out in subsection 5 will be sufficient. I submit that this course of action, in other words, the course of action set out in section 12.9, read together with section 12.5G, is appropriate in relation to the two honorable members who were involved and were found guilty in the 2014 incident, as in my view, none of the other penalties set out in section 12.5 of the Act would be sufficient. I now proceed to recommend to the committee for its consideration and deliberation the specific penalties that in my view are appropriate in relation to the affected members who have been found guilty of contempt of Parliament. I start with Honourable Members Matiase and Sondi, whom members will recall were the members who were involved and found guilty and had penalties imposed on them as a result of the 2014 process. In the present proceedings, as a result of their conduct, they've been found guilty once again of the same or similar charges. In the case of Honourable Matiase, the committee here in this process found him guilty of 7 charges, and Honourable Sondi is guilty of 5 charges. Once again, I reiterate, each one of these charges standing alone and each finding of contempt is on its own serious. The multiple and deliberate acts of serious contempt warrant an appropriately serious penalty. I submit that anything short of a sufficiently serious penalty will signal that the rules of the National Assembly, which rules the members of the House collectively imposed upon themselves, may be ignored, to be observed only in the breach, and may be transgressed without fear or concern of any consequence, let alone a serious consequence. I submit that such an approach is inappropriate and it is impermissible. A sufficient penalty in respect of these 2 members should be a serious penalty or penalties. In my view, that penalty is the penalty set out in section 12G of the Act. That is that Honourable Members Matiase and Honourable Member Sondi be suspended without remuneration for a period not exceeding 30 days, whether or not the House or any of its committees is scheduled to meet during that period. None of the other penalties set out in subsection 12.5 will be sufficient. The penalties that were imposed on Honourable Member Sondi as a result of the 2014 process was an order to apologize in terms of section 12.5C and a fine in terms of section 12.5F. I'm told, as I alluded earlier, that that penalty was not implemented. The penalty that was imposed against Honourable Member Matiase was in terms of section 12.5G, which is suspension for 14 days without remuneration. That penalty was also not implemented. These penalties from the 2014 process clearly didn't deter them from engaging in grossly disorderly conduct again in 2019, once again bringing the proceedings in the House to a halt, as had occurred as they had succeeded in doing in 2014. As for the remaining 14 members, and their names are set out on page 21, each one of them has been found guilty of 5 charges. There's an error on that page. It says they've been found guilty of 7 charges. If members could just be alive to that error, it is in fact 5 charges, each of contempt of Parliament. Taken individually, I say once again that each one of these 5 charges is serious. Contempt in the form of creating or participating in a disturbance of which these members have been found guilty is in and of itself a very serious form of contempt. It would warrant a sufficiently serious penalty or penalties, taken together with the further contempts of improperly interfering with and impeding the performance by the House of its functions, improperly interfering with the ability of the Minister of Public Enterprises to perform his functions, which further contempts they've also been found guilty of. The contempt of these members is very serious indeed. I submit that an appropriately serious penalty is warranted in the circumstances. The members acted intentionally, deliberately, and apparently in concert so as to disrupt the proceedings of the House, which they succeeded in doing. The proceedings of the House could not in fact proceed with all of these members in the House. They had to be removed, specifically in order to enable the business of the day to continue. No amount of reasonable intervention effect of the members reconsidering their conduct. I submit, therefore, that a sufficient penalty in relation to these remaining 14 members is that set out in section 12(5)(f) of the Act, which is a fine not exceeding the equivalent of 1 month's salary and allowances payable to each one of these members by virtue of the Remuneration of Public Office Bearers Act of 1998. Section 12, subsection 7, then guides the committee and the House, ultimately the House, as to how any fine imposed under subsection 5 may be recovered. This may be done by deducting installments from the member's salary as specified by the House in imposing the fine, or if not so recovered, by means of a civil action in a competent court. I leave that to the committee and ultimately the House to decide on in the course of their deliberations. These are my submissions, Chair, in relation to what I consider to be the appropriate penalties to be imposed on the affected members. What falls to occur now is for the committee to deliberate on those submissions so that it may make its own recommendations to the House regarding appropriate penalty.
Okay, thank you very much, Advocate Mayosi. Thanks for your submission. May I request honorable members that we break for about 10 minutes at the most. I've got some emergency that I need to attend to. It's now 10:37. Can we be back at 10:50? Is that fine, honorable members? Okay.
Yes, Chair. It's fine, Chairperson.
All right, thank you very much. Can we adjourn for about 10 minutes so that I can attend to this emergency, and then we'll be back at 10:50. So the meeting is adjourned. Thank you very much. Okay. Welcome back, honorable members. Let's continue with our meeting. We have received the submissions on the sanctions and the aggravating factors that were argued by Advocate Mayosi. I'm going to open up for members to engage, to deliberate, so that we can take a decision. Maybe just to remind the members that this committee has already returned the guilty findings. So the members have been found guilty by this committee in the past. What we have to discuss and deliberate on now is the appropriate sanction. Now, the sanctions, as Advocate Mayosi was arguing, they are contained in Section 12, subsection 5 of the Powers and Privileges Act. So those are there's a range of sanctions that this committee may recommend to the House to impose, which are about 7. In her argument, Advocate Mayosi is arguing that 2 of the members, for the reasons that she has mentioned, the appropriate sanction is 12(5)(g), and the other members, the appropriate sanction is 12(5)(f) of the Act. So I'm going to open for members to deliberate. There is also a question that we also have to discuss and agree on here, that there is outstanding sanction which was imposed in the 5th Parliament on 2 members, Honorable Matthias and Honorable Sonti. The matter was taken on review to the Western Cape High Court. The full bench ruled on that matter and dismissed that application. There was an appeal. That appeal has since been abandoned. So which makes the decision of the Western Cape High Court to be binding. So we'll have to also discuss on that issue, which affects the 2 members, and take a decision on the way forward on what must happen on that. Okay, that is that, members. I'm going to take hands now. I see no hands. Okay, I see the hand of Honorable Ndlozi. Can I get an indication of members who wants to speak so that we can just take the hands and then? Okay, we've got Honorable Ndlozi, Honorable Suela, Honorable Hussein, in that order. We'll take the others as they come.
No, thank you. Please just note our objection to this entire recommendation. Thank you.
Okay, thank you very much. That is the very brief submission from Honorable Ndlozi. Honorable Hussein, are we able to switch on the videos when you speak? Unless if it affects connectivity.
May I ask your indulgence, Chairperson? I'm unable to connect the camera on this device that I'm using, if you don't mind.
Okay. Yeah.
Chairperson, I listened very carefully to the submission by Advocate, and I'm in agreement that those members, the 2 members who were repeat offenders, that we should implement the recommended sanction as been proposed to us. And those, the additional members, I also agree that we need to implement the sanction as recommended by Advocate Mayosi. Thank you very much, Chair.
Thank you very much, Honorable Hussein. Honorable Suela.
Thank you, Chairperson. Thanks to Advocate for the well-presented document before us. Chairperson, we are not legal gurus, but the way Advocate has analyzed her observation, one is tempted to support her, more especially that this behavior occurred during 2014 and there were sanctions and they applied to High Court in the Western Cape and their application was dismissed. So to me, to be able to educate all of us public reps to behave well in the house and protect the decorum of the house, I believe we need to support her submission. Thank you.
Thank you very much, Honorable Suela. Can I get another members? Honorable Peters.
Thank you very much, Chairperson. I don't know, my video is on, but I don't see it, so it's fine.
Okay, we can see you.
Oh, okay.
Yeah.
Good morning, Chairperson and members. And I want to also join Honorable Suela with the word of gratitude to the to Advocate Mayosi for the well-crafted a report to us so as to guide us, but also for being able to research and go back into history, because it does help us to be able to make sure that we deal with issues that have got an impact on the decorum of the house. So I fully support the issue of the two Honorable Sonti and Matiane's issue, as well as the 14 others, because for me it is important that there is proper differentiation. But also, Chairperson, that I would recommend to this committee that we should follow through that up until the report is tabled in the House, we keep track of all these particular processes. But I fully support the recommendations of our evidence leader and the sanctions that are being imposed. In fact, Chairperson, I thought with the repeat offenders, the sanctions would have been even heavier. But the law being the law, like Honorable Suela has said, we're not legal gurus. We need to take a due regard to what the legal prescripts are saying, because you can't go beyond what the legal prescripts are saying. Thank you very much, Chair.
Thank you very much, Honorable Peters. Any other hand? Any other taker? I guess silence means consent from the other members. Okay, so let me just summarize what is the view of the meeting. So it is this committee's decision that the arguments and the submissions of Advocate Mayosi are accepted, and that two members, which is Honorable Sonti and Honorable Matthias, the appropriate sanction that this committee will recommend to the House is Section 12(5)(g), which says that the suspension of a member with or without remuneration for a period not exceeding 30 days, whether or not the House or any of its committees is scheduled to meet during that period. So the two members, the recommended sanction will be 12(5)(g), and on the other 14 members, The recommended sanction to the House will be 12 5F, which says a fine not exceeding the equivalent of 1 month's salary and allowances payable to the member concerned by virtue of the Remuneration of Public Office Bearers Act 1998. Yeah, of 1998. So that is the appropriate sanction for the 14 named members who have been found guilty. So that will be the sanction as recommended and as agreed by this committee. The committee further notes the objection of Honorable Ndlozi to the entire process, as he mentioned. Any other dissenting view? So this is the decision.
Chair Victor, it's not a dissenting
yes.
view, Chair, just for the purpose of capturing the minutes correctly. In terms of 12G, I think you are saying that it's suspension without remuneration. As that's the recommendation. Because if you read the section says with or without. So in this case, it should be without remuneration.
Yes, without remuneration. Without remuneration as recommended. This is the decision of the committee. Thanks for pointing that out. So that is the decision of the committee. I take it that members are also agreeing that we should recommend to the House that the sanction which was imposed in 2014 be implemented for the 2 members who are affected. And we will then request a report, if any, on the outcome of the High Court application and any implications for Parliament. So we'll get that report in the next meeting. Thank you very much, Advocate Mayosi. I think this brings us to the end of our interaction with yourself. As other honorable members have indicated, would like to take this opportunity to express our gratitude and our thanks to you for the assistance that you have been offering to this committee.
Thank you, Chair.
Okay, thank you very much, Advocate Mayosi. And thank you, honorable members. I think from now the report, the support team will prepare a report with our recommendations to the House, and the report will be do we have to come back and adopt the report, Victor, or should it just go straight to ATC?
Chair, what I could do is to circulate the report to you, and if you agree that it captures correctly the decision of the meeting, then it can be ATC, if that's agreeable to members.
Okay. Is that fine with members?
Yes,
The
Chairperson.
report will be drafted by the support team. It will be distributed to all the members, and all the members will be allowed an opportunity to make comments. And from there, we will take it to the ATC, and we will meet up with the report in the House. But basically, it's going to be the summary of our process from the beginning up to today.
Agreed.
Chairperson.
Agreed, Chair.
Chair.
All right, Honorable Ngaleka.
Yeah, I've got a different view. I think after they have done with the report, can't we just have a few minutes meeting so that we adopt the report officially, so that we don't have some loopholes, please? Thank you,
Okay.
Chair.
I support.
I think that is in order. I think that is in order, Honorable Malulek. We'll just have scheduled a 30 minutes meeting to adopt the report.
Yes.
Once the report is ready, so we'll advise members of the meeting Thank you very much, honorable members. We'll then, I guess, meet again when we adopt the report. It's not going to be a very long.
Chair,
Thank you, Chair.
Chair, we still have the minutes of the 4th of March still to be considered by the committee before we close.
Okay. Oh, yes. Thanks, Namhla. Okay, before we conclude, members, let me put to you the minutes of the 4th of March. Any mover?
Chairperson, Honorable Suela, I move for the adoption of the minutes as a true reflection.
Honorable Suela moves for the adoption.
Honorable
Very brief. Honorable Tseke seconds.
Yes.
Any dissenting view? None. The minutes are therefore agreed to. Thank you very much, honorable members. Enjoy your Easter weekend. We'll meet each other when we adopt the report. I think hopefully it's gonna be before we resume with our work in Parliament. We'll just request an approval for about 30 minutes meeting. I think in that meeting, we'll ask that the administration must also prepare us another report on the outcome of the court case, so that as we report to the House, we report on all these matters, all of them at once. Okay, thank you very much, members. The meeting stands adjourned.
Thank you, Chairperson. Nidle kahle le Good Friday. Ingadli nina.
Thank you very much.